Welcome to this webinar on fixed costs in personal injury cases. My name is Timothy Salisbury, and I'm going to talk you through some of the key issues in fixed costs for personal injury litigation. Hopefully by the end of this presentation, you'll be familiar with the concept of fixed recoverable costs and their basis within the rules of the CPR. I'll also run through a few example calculations and will endeavour to highlight some potential pitfalls. So what do we mean by fixed costs? Fixed costs, or predictable or predicted costs in litigation, are specific amounts mainly prescribed by Civil Procedure Rules Part 45 that are recoverable by one party from another in certain circumstances in litigation unless the court orders otherwise. So what this means is that either the amount or the method of calculation of the amount is prescribed by the rules. These do not necessarily affect whether fees and disbursements that you have incurred are payable on to those parties, so medical expert fees or counsel's fees. And you may find that a medic or counsel will charge a greater amount than the recoverable fee. That is still permissible, but of course you can only recover the fixed fee. Fixed recoverable costs is conceived as a fixed recoverable costs is conceived conceptually as a swings and roundabouts approach. The practical effect of fixed costs or fixed recoverable costs is that some cases will be more profitable than others. As Lord Justice Briggs in the Court of Appeal case of Sharp and the Leeds City Council said, the fixed cost regime inevitably contains swings and roundabouts, and lawyers who assist claimants by participating in it are accustomed to taking the rough with the smooth in pursuing legal business which is profitable overall. So what does that mean? If you imagine two cases of equal value, they both settle at the same time for the same fee. One, however, was very straightforward, with few documents to prepare and little correspondence. The other involved protracted correspondence with multiple defendants, multiple witness statements, and voluminous disclosure. In a case to be assessed on the standard basis, the latter would likely recover more in cost than the former. However, on a fixed basis, they both recover the same fee. The business model requires the firm to have a basket load of cases, offsetting the relatively high-paid quick wins with the more protracted, harder-fought victories. And of course, that says nothing of those cases which are unsuccessful. CPR Part 45 provides the rules and mechanisms concerning fixed costs. I will endeavour to deal with some, but not all of these during this talk, although I will focus predominantly on the operation of Section 3A. I can gloss over Section 1, which concerns the fixed costs of commencement, entering judgment, service, and enforcement in certain non-personal injury claims. Broadly, the idea is that currently the cases covered by most of these types of fixed costs are, on the whole, lower value, more straightforward cases than those where costs are awarded on the standard scale. Towards the end of this talk, I will look at the future of fixed costs. Similarly, Part 6, which sets out fast-track trial costs, namely counsel's fee. The table at CPR Rule 45.38 prescribes the recoverable amount of counsel's brief fee. But do note that you would have needed to have stated the agreed fee in your cost schedule. All the table does is prescribe the level of recoverable fee. As I touched upon earlier, it doesn't prevent counsel agreeing a higher fee or a lower than the prescribed fee, nor does it affect the amount payable to counsel if a lower amount than agreed fee is recovered. It's also worth noting that CPR Rule 27.14.2 prescribes the limited costs and disbursements which are recoverable on the small claims track. Section 3 deals with claims which start in the relevant low-value personal injury portal. That's CPR 45.18. prescribes the costs for cases where liability is admitted in the portal at stage 1 and sets out those costs which are recoverable in table 1. Stage 1 costs should have already been paid in the portal. Stage 2 are payable if settlement is reached at stage 2 in the process. If the matter doesn't settle at stage 2 and the special Part 8 procedure starts, then the stage 3 costs kick in. There are 3 types of costs at stage 3. Those are defined in the CPR at Rule 45.18.2. You can see on the slide the Type A, Type B, and Type C fixed costs. Type A costs are the legal representative's costs, so effectively profit costs for the solicitor's firm at that stage. Type B costs are the advocate's costs, so the cost of counsel if there is an oral hearing. And type C is the cost of a quantum advice if the claimant is a child or protected party. If parties can't agree quantum at stage 2, as I say, Part 8 proceedings will need to be issued and quantum determined at a hearing, that is to say, determination at stage 3. And the rules provide that you may recover some or all of stage 3 costs from table 6. The reason I say some or all is because, as I've already run through, the types of costs available at stage 3 relate to particular costs or disbursements. So, for example, if the matter is determined at stage 3 on paper, then no advocate's fee is recoverable, just type A. If, for example, the matter goes to stage 3 and the party is a child or protected party, then type A, type B, and type C costs will be recoverable. It's worth noting, though, that the stage 3 hearings have their own operation of the Part 36 procedure. In essence, as you can see from the bullet points at the bottom of this slide, if the claimant beats the defendant's offer, but not its own, then it can recover costs from the table. If the claimant beats its own offer, then it gets the costs from the table, plus, as I've described them, the Part 36 bonus prizes. So that is interest on damages not exceeding 10% above base rate for all or some or all of the periods starting with the date specified in Rule 36.26. Also the fixed costs, as I say, from 45.20. Interest on those costs at a rate of not exceeding 10% above base rate, and an additional amount calculated in accordance with 36.7.4D. So that's the 10% of damages. But beware that if the claimant fails to beat the defendant's offer, then the claimant must pay the defendant the applicable stage 3 costs and interests on those costs from the deemed date of the protocol offer. Given this sanction, it's well worth claimants making realistic and competitive offers to avoid losing out on costs or to claim the rewards of Part 36. Moving now to Part 45, Section 3A, which relates to claims which no longer proceed in the portal, and that's usually because liability has not been accepted. I'll focus on this in some detail, and I hope that after working through some examples, you will feel confident working with fixed recoverable costs in contentious PI matters. Looking first at the basics, the costs are fixed and awarded in line with Table 6B at CPR 4529C or 4529E, depending on the type of proceedings. They're calculated by identifying the relevant stage that proceedings have settled or are disposed of at trial, and the costs are calculated by reference to the applicable section of Table 6B. Typically, costs are awarded in the basis of a fixed sum and an additional sum equal to a percentage of the damages awarded or agreed. And in addition, the relevant trial advocacy fee if disposed of at trial. The reason I've written sum equal to a percentage of damages awarded or agreed is because from the wording of the table, you will see on the next slide that it is set out as percentage of the damages. So for avoidance of doubt, this is not creating any right for the solicitor to take a share of the claimant's damages. Rather, it's a metric by which the additional sum to be awarded in costs may be calculated. Please don't forget that there is also a 12.5% uplift if the solicitor for the claimant is based in the geographic area listed within PD 45. Which I will come to a little later. So I'm going to take you through 3 worked examples. I've included on the slide the tables 6b from the rules as you'll see it set out in the white book. First example. Let's say that the claimant's claim has fallen out of the portal, but is settled before proceedings are issued for the agreed damages of £5,000. The relevant box to look at is box A, because the matter is settled prior to issue. Because damages don't exceed £5,000, the claimant is entitled to the greater of either a fixed fee of £550 or the prescribed fee of £100 plus 20% of the damages. So in this case, the second figure is 20% of £5,000, so £1,000 plus £100, coming to a total of £1,100. As the second method of calculation is the greater one, fixed costs of £1,100 may be awarded as profit costs. Second example. Let us now say that the claimant issues proceedings. The matter is allocated, but no trial date has been listed. The parties agree to settle again for damages of £5,000. So the relevant box is box B. We use the middle column of the 3 because of the date of settlement, as you see, on or after the date of allocation under Part 26, but prior to the date of listing. Profit costs comprise of the fixed sum of £1,880 plus £1,000 being 20% of the agreed damages. So profit costs in this case are £2,880. Finally, the third example. Let us say that the matter runs to trial and the claimant is successful at trial. The judge awards a total damages in the sum of £5,000. Here, the relevant box is box C because the matter has proceeded to trial. Profit costs therefore comprise of the fixed sum of £2,655 plus £1,000, again being 20% of the damages, so a total of £3,655 as profit costs. Additionally, the claimant can recover a trial advocacy fee, in this case £710, as the damages were more than £3,000 but less than £10,000. So as can be seen in our 3 examples, settlement of a claim for the same sum has resulted in a range of fixed recoverable cost profit costs, depending on the date of settlement, ranging from £1,100 up to £3,655 plus trial advocacy fee. One point to note with calculating costs within table 6b is that the Court of Appeal has confirmed in the case of Bird and Acorn 2016 EWCA Civ 1096 that cases listed for disposal hearing is treated the same as listing for trial, and the table should be construed accordingly. Don't forget, again, here's a reminder that to claim London weighting, uplift of 12.5% where it is applicable. If your representative practices in certain areas, which I've set out on the slide, but which broadly are broadly London and certain surrounding courts, then the claimant may recover the uplift. It can be quite a significant amount of money, so don't forget to claim it or remind your counsel in their carefully drafted brief that they should claim it. Finally, on this point, don't forget the VAT. My examples within these slides are all exclusive of any applicable VAT. Moving now to disbursements, you will want to be aware of the list of recoverable disbursements which are set out for RTA cases at Rule 4529I. That lists permissible disbursements, for example, medical fees, medical records, engineers' fees, court fees, expert fees, etc. There is also a provision at 4529I2H, which permits the recovery of any other disbursement reasonably incurred due to a particular feature of the dispute. This is worth noting that although it may suggest it is open for creative interpretation, in practice, it's rare to see it successfully deployed. As you can see from the slide, I've referred to the decision of Aldred and Tan. Aldred concerned the recoverability of the cost of a quantum advice required as the claimant was a child, which, whilst it was recoverable and proceedings under Section 3, is not listed as a disbursement recoverable under proceedings under Part 45(3)A. The Court of Appeal held a disbursement would be incurred due to a particular feature of the dispute within CPR Rules 4529I2H, where the expense was generated by or linked to a feature of the dispute itself. In Aldred, the need to obtain counsel's opinion on settlement had been necessitated by reason of the claimant's age. It was not an expense incurred due to a particular feature of the dispute and was therefore not recoverable. This judgment also includes an obiter comment, which I'm certainly aware has been followed in numerous cases, that interpreters' fees are similarly irrecoverable as they pertain to a particular feature of the claimant and not to a particular feature of the dispute. So how do we deal with matters when single proceedings are issued for multiple claimants? This is a necessary point to examine because, of course, the claims notification form in the protocol can only have the name of a single claimant, whereas the CPR requires as many claims that can be properly dealt with together to be issued in the same proceedings, which is an apparent tension. I've set out on the slide 3 decisions on the point, which have slightly different outcomes. In the case of Neary, His Honour Judge Pearce in the County Court at Chester had 2 co-claimants and held that each was entitled to recover the fixed fee and the advocacy fee referred to in paragraph C of Table 6B. The judge held that the wording of Table 6B stated that it dealt with fixed costs that were recoverable where a claim no longer continues under the RTA protocol. Under the protocol, there's no possibility of including the claim of more than one injured person in one claim, and so awarded 2 sets of costs and 2 trial advocacy fees. The second case, Karnitska and Zborek, was a case with which I was involved. The court agreed upon detailed argument heard on the applicability of the fixed costs or otherwise. The court agreed with the reasoning in Neary, awarding 2 sets of solicitors' fixed costs. However, only a single trial advocacy was recoverable on the basis that there ought to be broad equivalence between parts 3A and part 6 of the CPR, of CPR 45. Part 6 effectively prescribes that where multiple claimants are represented by the same counsel at trial, the brief fee is calculated on an aggregate basis of the damages. So total up the total damages for the 2 claimants and claim the larger brief fee rather than 2 sets of a lower brief fee. I should say that in Karnitska, the judge expressed some hesitation at the result because it had required him to read across rules from different sections and include them. Permission to appeal was sought and obtained, but unfortunately, the claimant, and one imagines the claimant solicitors, didn't have the appetite to pursue the matter to appeal when the only matter in issue was the recoverability of counsel's brief fee. There's a 2022 case of Meloy where His Honour Judge Glenn reached the same conclusion as Neary in relation to fixed cost. It was argued that there would be a windfall to the claimant solicitors if they rewarded 2 sets of costs. And the judge considered that whilst that may be so, the essence of fixed cost is that there will be swings and roundabouts. The outcome should not inform the construction of the rules, save in the most exceptional cases. Interestingly, there was no discussion of the trial advocacy fee in that case. So in summary, multiple claimants should equal multiple awards of costs when brought in the same proceedings. That's definitely the trend in the reported available written decisions from the circuit judges, which, whilst not binding, would certainly persuade most district judges. What I would ask is that when you prepare costs schedules, even for cases which are dealing with fixed recoverable costs, that you produce itemized schedules to set out the 2655 plus 20% plus itemized disbursements together with invoices and receipts. And you do that for each claimant. Looking to offers to settle, part 36 at rule 3620 provides that the claimant is entitled to costs up to the date that the notice of acceptance was served on the offeror, and that they're calculated by reference to the table 6B, 6C, or 6D. I would just also touch on part 36 points. The recent Court of Appeal case of Ho and Adelakun confirmed that where part 36 offers refer to assessment, the claimant's costs will be calculated on fixed cost scale, not least because that requires an assessment of some sort. I will come back to offers to settle and their applicability to fixed costs in a little while. CPR 3621 provides cost consequences following judgment where the claimant obtains judgment less advantageous than defendant's part 36 offer. In those cases, the claimant will receive fixed costs to the applicable level at the expiry of the relevant period, but that the claimant must pay the defendant's costs from that date until judgment. Worth bearing in mind that even with quoques in a low value claim, a failure to accept a good part 36 from the defendant could end up in wiping out or but wiping out the claimant's damages. What happens when the claimant recovers judgment at least as advantageous as the claimant's part 36 offer? The rules when drafted were unclear, and it took until the Court of Appeal case of Broadhurst and Tan in 2016 for the correct method of calculating costs where the claimant had made a part 36 offer until the rule became clear. It's now settled law that the claimant should get indemnity costs from the date that the offer became effective. It's fixed, as you can see in my notes. The combined effect of 3617 and 3621 means that the claimant making a successful Part 36 offer is entitled to fixed costs to the last staging post by reference to Table 6b, and then costs assessed on the indemnity basis from the date the offer became effective. I've also added the practical implication. It's crucial that if you want to recover indemnity costs, claimant solicitors must prepare and serve indemnity cost schedules from the effective date. Sometimes one receives a brief which suggests if our Part 36 offer, if we have a successful Part 36 offer, ask for detailed assessment, it will almost never be considered proportionate for the matter to go to detailed assessment. A district judge or circuit judge dealing with a fast track case, such as ones to which this fixed recoverable cost regime applies, will want to assess costs on the day. And if there's no schedule, the court cannot and frankly will not assess these costs, and you will lose them. So please do prepare those schedules and make sure they are easy to understand so that it's clear what work is done from the date, the effective date. I'd like to touch on offers that are made other than under Part 36. In the recent case of Doyle and M&D Foundations and Building Services from July this year, parties settled the matter by consent order, but outside the provisions of Part 36. I believe this was because the offer was made too close before the date of trial for the period to be effective. They settled on terms that the defendant was to pay the claimant's costs, such costs to be the subject of detailed assessment if not agreed. The Court of Appeal held that by coming to an agreement in those terms, the parties had contracted out of fixed recoverable costs, and that their express agreement for detailed assessment meant the parties had agreed that the costs be assessed on the standard basis. The key difference between Doyle and the case of Ho and Adelakun was that Ho was settled using Part 36 procedure. And so the distinction was drawn on that basis. So if you are making a call to bank offer or any type of, or if you're drafting a settlement offer outside Part 36, please be aware that if you make it in the terms such that costs are to be the subject of detailed assessment if not agreed, you may be placing yourself within the detailed assessment regime. Particularly worth bearing in mind if you are going to be the paying party, that if you thought you were going to foot the bill for fixed recoverable costs, but find yourself not only, you find yourself heading off to detailed assessment with the additional expenditure and time that incurs. As we come towards the end of this presentation, I'd like to look at defendants costs. And as you see, CPR Rule 4529F deals with the defendants costs. And that provides that if the court orders costs in the defendant's favour, the court needs to have regard to the amount that would be payable to the claimant at the same stage of proceedings. And any costs awarded must not exceed that amount. So again, you would have reference to Table 6b, stand effectively in the shoes of the claimant, look at the amount of damages that may be awarded or has been claimed, depending on the stage at which you're arguing this. And the court will make sure that any costs awarded do not exceed the amount that could have been payable to the claimant at that same stage, effectively placing a cap on the amount recoverable. But you mustn't forget quoques. The first big point to note is that quoques will apply until disapplied. But of course, do note that if the defendant's awarded the costs of an interim application and the claimant then is awarded damage, don't forget that the defendant's order will be enforceable without any further order of the court. Part 36 may also lead to an award of costs in favour of the defendant, but again, remember, quoques will apply. And then the exception to quoques at CPR Rule 4529F10, which provides that where one of the exceptions to quoques apply, the court may assess the defendant's costs without reference to 4529F. So effectively suggesting a summary assessment on the standard basis can be undertaken. This means that in those cases where quoques has been disapplied for one of the reasons set out at 4415 and 4416, neither the fixed recoverable costs nor quoques regimes apply to the calculation of award or the enforceability of those costs. So in brief, 4415 is where a case is struck out because the claimant disclosed no reasonable grounds for bringing or defending the claim, or proceedings are struck out as an abuse of process or struck out due to conduct which is likely to obstruct just proceedings. 4416 are circumstances where the finding of fundamental dishonesty or a finding that the claim is brought for the benefit of a person other than the claimant or a dependent. If one of those applies, then the court doesn't need to have regard to fixed recoverable cost regimes. Defendant solicitors will therefore want to prepare a full schedule of costs and invite a summary assessment if they think one of those outcomes is likely. Defendants' costs are also covered in counterclaims. If the counterclaim includes personal injury, the costs regime, the fixed recoverable cost regime applies as if they were a personal injury claimant themselves. If there's no personal injury involved in the counterclaim, then Rule 4529G prescribes that the court will award a sum equivalent to 1/2 of the applicable Type A and Type B costs in Table 6 from Rule 45, and that's Rule 4529G2. So in practice, that means that a defendant with a non-personal injury counterclaim will look to recover £250 or £400, depending on the value of the claim. And if you want to go back to slide 5 of this presentation, you should see those costs set out on that slide. So what is the future of fixed costs? Well, more to come. In 2017, Rupert Jackson produced a supplementary report, and in 2021 there was a government response with the proposal that effectively the fixed recoverable costs regime would be introduced to all civil cases in the fast track up to £25,000, that the fast track itself will be extended to include cases up to £100,000. Some other recommendations, such as that for an intermediate track, was not taken up by the government. And what I think we can expect to see is the banding system, that all fast track cases will be allocated to a band, each with their own level of fixed recoverable costs, calculated by reference to anticipated complexity of that particular claim. It's actually quite an interesting provision that if there is a challenge to the assigned band, if that challenge is unsuccessful, then the challenging party will incur a sanction for unreasonable behaviour. So whilst I think it's yet to be seen exactly how everything will play out, I think we can expect to see an expansion of the fixed cost regime and potentially punitive sanctions for anyone that doesn't agree with where they've been placed. So that brings me to the end of this talk. If anybody has any questions arising, please do feel free to be in touch. My contact details are on this slide, and I'm sure that I or any other member of the personal injury team would be very happy to help you should you have any queries about fixed recoverable costs or anything else. So all it leaves me to say is thank you very much for attending the webinar, and I look forward to working with you in the future. Thank you.